Will the gentleman yield?
Yes, sir.
It is in Georgia the law that people are required to wear seat belts if they're in a passenger vehicle, correct?
That's right.
So when we talk about it being no fault of their own, there actually is a fault there. They're violating the laws of the state of Georgia, correct?
In that instance,
in that
yes.
Instance. Okay, and I understand that the gentleman has a problem with there not being a requirement for pickup trucks, but the current state of the law is that isn't the case. Aren't there other situations, and the term that we lawyers use is negligence per se, that when you violate a statute, not only does it go to whether or not you have a reduction in damages, but it actually goes to whether or not the party is at all liable for the damage at all, correct?
That's true.
So as I understand the argument, your argument is that not only should a violation in this particular case not apply to negligence, but it should not even apply to damages reduction. And as I understand it, because we should apply it across the board, and because you're worried that insurance companies will come in there and argue for a reduction of damages to nothing. Is that correct?
It's a convoluted question, but as I understand it, those are two of the reasons that I've cited that the bill is not good.
Currently now, in these type of cases, we often have experts.
I can't hear you.
We often have experts, do we not, in court now, battling over whether or not there was contributory negligence, whether or not there's a reduction in damages. And as I understand the gentleman, do you object to insurance companies being able to have their day in court to say, in fact, but for this person's conduct in violation of the laws of the state of Georgia, this damage would not have happened?
Well, the problem with that is whether or not we talk about somebody being without fault. You know, in creating the wreck itself, the failure to wear a seatbelt plays no part whatsoever. And I can't think of any cases where it would play a part. And so the only reason the insurance company is going to bring it up is to try to defeat your right to recover by arguing that your damages would not have been incurred except for your failure to wear a seatbelt. That is, in my opinion, it's a rule that's been crafted and it's in the law now because there is a balance to be struck there. And when an insurance company has unlimited resources to bring in experts and what have you, to raise a question, that's maybe all that they need to do is raise the question. Well, you know, say that from my examination of the injuries, they're inconsistent with the use of a seatbelt. Not definitive, but to raise the question. In many cases, that is going to keep your average person from being able to get a fair trial because most of your average citizens are not going to be able to pay the experts like State Farm and Allstate and some of those companies can.
Well, you would agree with me that most of the people who are representing plaintiffs in these cases are, in fact, on contingency, so that it's the lawyers, not the individuals, that are fronting those expenses, and they recover them out of any eventual damage, right?
Well, I would agree with you that most of those are contingent fee cases, but I also remind you of the bar rules which say that a lawyer is prohibited from acquiring an interest in the outcome of the litigation, and therefore a lawyer in that situation is only advancing expenses for which the plaintiff is ultimately liable. So in many cases, you're going to have a situation where the plaintiff may either be required to pay them up front or may be required to somehow finance them. And you know, a lot of people in these types of cases just don't have that sort of deep pocket.
And is the idea, as I understand the gentleman's objection, that we don't trust the juries to be able to sift through this evidence and make a determination for themselves about how much a reduction should be made, if any?
No, I think that I trust the juries. What I don't trust is the insurance companies and the experts that they're going to bring in from out of town. And to create a cottage industry for insurance company experts to come in every motor vehicle case and to bring in an expert that's going to require the plaintiff to do that and then have separate independent litigation just over that one point, I think is unwarranted and unwise.
Thank you.
Thank you.
The gentleman has 14 seconds. I believe I'm going to call that.
Mr. Speaker, I'll yield the will. Thank you.
Thank you. Chair recognizes Representative Lindsay for the purposes of speaking on the bill.
Thank you, Mr. Speaker. Let me first start off by pointing some things out that I think are very important about this bill. First off, let me start off by saying I want to thank both the Georgia Trial Lawyers Association, and those are the plaintiffs' lawyers in this state, representing the plaintiffs' lawyers, and the Georgia Chamber of Commerce, because they worked on this bill not over the last few weeks, but quite frankly over the course of the last year to come up with a good compromise. And I think that's exactly what this bill is. This bill is a good compromise that has been worked out between the business community and the plaintiffs' bar to try to fashion a level playing field. And yes, that's exactly what we are doing here. We are fashioning a level playing field. I think that's the first thing you need to understand. The second thing you need to understand is that the existing law is not the general rule when it comes to liability and damages. The existing law is an exception to the general rule. The general rule of law in this state is that an individual is responsible for their own behavior and responsible for taking care of themselves even when they are injured in an accident. It's called, you have a responsibility to mitigate or lessen your damages as much as possible. That's what the general law is in this state. When it comes to every other possible area of liability, you are responsible for making sure that the damages that are incurred when you're in an accident are as low as possible. There's only one exception recognized that I'm aware of in automobile cases, and that is the failure to wear a seatbelt. The third thing I want to point out is this. I've been practicing tort law for 25 years. I've represented giant corporations in products liability cases, and I've represented individuals in automobile cases. In both cases, in both situations, the purpose of tort law is simply this. You are trying to promote reasonable behavior, responsible behavior. Whether you are a giant company putting a product out in the stream of commerce, or you are an individual driving down the road, what the tort law is supposed to do is promote responsible behavior. And that's what the key is. And that's what we've got to ask here today. If you believe that it is responsible behavior for you to drive down the road without a seatbelt on, then vote against this bill. If you believe that as we have come as a society to understand what responsible behavior is while you're driving, that you should be wearing a seatbelt, then you should vote for the bill. It's really that simple as to whether or not you believe wearing a seatbelt is responsible behavior, one way or the other. And let me give you a very personal example of why I believe so passionately in this bill. It has nothing to do with the fact that I'm a lawyer, but it has everything to do with the fact of what happened to me about 35 years ago. And that is, I was in an accident, and I was not wearing a seatbelt. And instead of being able to walk away from that accident, I spent several weeks in the hospital. And I've got the dent in the forehead and the scar up through my scalp that is now more and more evident as my hair falls out to prove it. It is really quite simple. If you believe and if you understand, as I have come to understand in a very personal way, that seatbelts save lives, then you vote for this bill. If you do not believe seatbelts save lives, then vote against this bill. That's the bottom line. This bill does not tip the balance in favor of the insurance companies or the defendant or anyone else. The burden still lies with the defendant. The defendant has to prove that the seatbelt would have made a difference. I find it really interesting that some folks have come up here and criticized the part of the bill dealing with the experts and the necessity of the defendant to have an expert show that the seatbelt would have made a difference when it's the plaintiff's lawyers who put that in there. The plaintiff's lawyers are the ones that insisted that that provision be placed in the bill, and now we are having folks say, well, that's put in there to help the insurance companies. Just the opposite is the case. You've heard the debates on both sides. You've heard the questions on both sides. I'm not going to belabor the point any further. But once again, I do want to go back to the bottom line. Do seatbelts save lives? If they do, then we need to have, through our tort law, promote that responsible behavior of having people wear seatbelts. And then I ask you to vote yes, if that's what you believe. It's not only what I believe, based on my experience as a lawyer, but it is what I know as an individual and I have the scars to prove it. Mr. Speaker, I yield the will.
You wish to yield for